Yes, Mr. Royston.
My lady, my lords, my learned friend has asked if he can briefly address the court on one matter of clarification arising from his submissions that he's thought of overnight. I have no objection to that if the court is content.
We need this before your reply, do we?
Well, I just think in fairness to Mr. Royston, I correct one point I made in response to a question of your ladyship.
Oh, of course then. Yes, certainly.
You asked whether if someone came to the host state with resources, they were sufficient arguably for themselves, but not for their partner who was claiming income-related benefit, social assistance. Would those resources have to be sufficient to take
Yes.
the partner off benefit?
You said they would.
I said yes.
Yes.
I now realise my answer should have been slightly more nuanced.
All right.
Because I overlooked the first sentence of Article 8.4 of the directive. The answer is, in terms of the reference amount set by reference to the eligibility threshold for social assistance, the couple wouldn't, the EU citizen wouldn't meet that threshold, but then it would be a matter for individual assessment of the personal circumstances of the couple, whether in the round the ultimate view was
Yes.
that they didn't meet the conditions, that he didn't meet the conditions under Article 7.1b. So less.
No, well, I'm grateful for the clarification, but I have to say I don't know about their lordships, but for my part, I'd had it in my head that was always going to be subject to the caveat of 8.4. But thank you for the clarification.
Thank you.
I'm sure it's helpful to Mr. Royston. Thank you. Yes, Mr. Royston.
Thank you, my lady.
Round two.
Yes. First, I was going to
social assistance.
I was going to explain or attempt to explain the distinction between social assistance, social security, and special non-contributory benefits, and that accounts for one of the two gifts that the bench has received from myself and my learned friend this morning. The small folder is from the respondent. The single authority is from the appellant, and he'll explain the significance of that later. So I'm dealing just with this small folder. I think, I don't know who is working electronically and who's working from paper, but I know that my junior has sent it electronically to your clerks.
Thank you very much. That's very helpful.
Tab 1 of this supplementary authorities bundle is simply providing the statutory provisions that control court's jurisdiction in this appeal. I've explained them already and don't need to say anything more about them. Sections 13 and 14 of the Tribunal's Courts and Enforcement Act.
Thank you.
Can I just note that is this right? Section 13, subsection 6, capital A, lays down the second appeal test.
Yes.
So
Lord Justice Lewis was satisfied that this appeal did meet that test.
even in relation to grounds 2 and 3.
Well, that I must admit, on my feet, I'm not sure. I can't immediately remember what the authorities say about whether, if satisfied that one ground meets it, it's necessary for every ground separately to meet it to be given.
They don't have to.
They don't.
That's very helpful.
Authority from this court on that point.
Right.
I thought that there probably would be. So I suppose we don't know whether Lord Justice Lewis thought that they all met that test, but presumably he was satisfied on ground 1.
Yeah.
I'm going to start with social.
Just turning up the reasons. Lord Justice Lewis said the grounds have a realistic prospect success and raise important points of principle or practice not previously addressed directly in the Court of Appeal. So he's just wrapped them all up together without specifying.
A very practical, pragmatic approach. The case of Commission and Parliament, which is the third tab, C29905, is a judgment of the Court of Justice from October 2007, where it heard an action by the European Commission challenging the categorisation of a number of member states' benefits. And in particular, so far as it's relevant to this appeal, the UK had at that time classified disability living allowance, which is the precursor to personal independence payment, as special non-contributory benefits. And I'll come in a moment to how that is defined. The court, there were a number of other states that were accused by the Commission of having miscategorised their benefits. The Court of Justice agreed with the European Commission that the care element of disability living allowance and the entirety of carers allowance were pure social security benefits, not special non-contributory benefits. And say I'll seek to explain what those terms mean. The assistance of this case, as well as providing us with an explanation of how the court defines certain terms, is that it means that actually the potentially controversial benefit that's at issue in this appeal has been specifically examined by the Court of Justice and has been authoritatively categorised as social security. And that's no doubt why the Secretary of State concedes its character. So that saves the domestic courts from having to, while obviously it's helpful to understand the differences, it saves the domestic courts from having to do any application of law to facts, because it just so happens that the Court of Justice did it. So I wonder if you could turn up paragraph 56, which is at 33 of your supplementary bundle, because that provides a useful summary of what is a social security benefit. It's distinguishing. It starts, you'll see, my lady, my lords, with the words by contrast, and it's contrasting it with a special non-contributory benefit. A benefit is regarded as a social security benefit where it is granted without any individual and discretionary assessment of personal needs to recipients on the basis of a statutorily defined position and relates to one of the risks expressly listed in Article 4.1 of Regulation 1408/71. Regulation 1408/71 was the original Social Security Coordination Regulation. That's been replaced since Commission and Parliament by Regulation 883/2004, is parts of which are at tab 2, and the reference that was to Article 4 of 1408/71 is now to Article 3 of 883/2004. I invite you to turn into tab 2, page 9, looking over to to page 10, and you'll see the prescribed.
In the new bundle.
Oh, sorry.
I'm so sorry, my lord. I think all of my references, unless I specifically say, will be to the mini bundle at the moment. So you'll see that there are a number of social risks identified, and then a benefit which relates to one of those social risks is a social security benefit if it meets the other conditions that were set out in the passage that I mentioned a moment ago. My Lord Justice Singh asked yesterday about the relevance of whether a benefit is a contributory benefit or not, because different countries organise their social security systems in different ways. For your note, I'm not going to invite you to turn it up because it's a small and hopefully uncontroversial point, but the case of A and Latvia, which my learned friend took you to, which is tab 30, page 833, at paragraph 37 of that judgment, has the Court of Justice expressly saying how a benefit is financed is immaterial for its classification as a social security benefit. It just box that point off. It's not merely that it's not determinative, it's just not a consideration at all. Staying in Regulation 883/2004, as well as Article 3, I've given the court Article 70, which starts at page 11. And it contains a statutory definition of special non-contributory cash benefits. The court has an advantage here because social security and social assistance have a meaning that has to be derived from the case authorities, but there's a specific definition of what's meant by special non-contributory cash benefits. And you can see that it's multi-partite. There's an intention function, which is 2A on page 12. Must be providing supplementary, substitute or ancillary cover against risks covered by the branches of social security referred to in Article 3, and which guarantee the persons concerned a minimum subsistence income having regard to the economic and social situation of the member state concerned, or offer solely specific protection for the disabled closely linked to the said person's social environment in the member state concerned. And this is the sole relevance of contributions, B, where the financing exclusively derives from compulsory taxation intended to cover general public expenditure, and the conditions for providing and for calculating the benefits are not dependent on any contribution. And C are listed in Annex X to the regulation, which means that the member state has to take the positive act of informing the European Union that it intends a benefit to be treated as such. And special non-contributory benefits are a mixed category because they have some features of social security, yet they have some features of social assistance. If we turn back to page 36 and look at paragraph 67 of Commission and Parliament, page 36, para 67, here the court is looking at, oh, I'm sorry, I mentioned DLA and attendance allowance, and carers allowance. In fact, the court was looking at DLA, disability living allowance, attendance allowance, and carers allowance. 3, not 2 benefits. Contrary to what the United Kingdom asserts, only the DLA, disability living allowance, can be considered to include a social assistance component. The other 2 benefits at issue have a single purpose, which is akin to that of the Swedish disability allowance. That was one of the others that was being looked at, namely to help the disabled person to overcome, as far as possible, his or her disability in everyday activities. A Accordingly, those three allowances, as well as the preceding allowances, must be regarded as sickness benefits.
Now that's very helpful, but just tell us where that feeds into your overall submissions, because so far as I understand it, there's no dispute between you as to those components of the makeup of financial assistance in this case, which was social security and social assistance.
Yes.
So
The
interesting though it is, I'm
Yeah.
not sure how much time we need to spend on this topic.
The reason that it's significant is explained in S, because
Which relates to ground,
1.
still in ground 1.
Yes. And perhaps if I take you straight to it. Oh, let me just first give you, for your note, without taking you to them, Bray paragraph 61, which contains a definition of social assistance, where the critical feature is that it's means tested. And
I think we've looked at that already.
yes,
haven't we?
that's at page 576. And that's also said in S at paragraph 46 at page 904. But where that analysis feeds into ground 1 is at paragraph 54 of S on page 905, tab 32 of the main bundle. So I'm now done with the mini bundle.
Sorry, where are we going now? To Bray?
The case of S, tab 32 of the main authorities bundle, page 905.
Paragraph number 50.
54.
Thank you.
And here, S is looking at the equal treatment obligation in Article 24 of Directive 2004-38, and is dealing with a member state's argument that it should be allowed to exclude a social security benefit in the same way that it would uncontroversially be allowed to exclude a social assistance benefit. The court rejects that, and at paragraph 54 it says that interpretation is consistent with the objective of Article 24.2 of Directive 2004-38, which aims according to recital 10 of that directive. And that's important because that recital has repeatedly been referred to by the court as animating the construction of Article 7 as well. To maintain the financial balance, not of the social security system of the member states, but of their social assistance system. So the Social Security Coordination Regulations, 883/2004, contain very detailed provision allocating responsibility for member states of the financial burden of social security benefits. That multifactorial bringing together of competing objectives and interests has been done in 883/2004. It reinforces the distinction that European law recognises between social security and social assistance, and for this moment accepting that social SNCBs count as social assistance. The distinction there reinforces the proposition that the proper concern of Article 7 is the extra burden on social assistance rather than a broader one of protection of public finances.
I'm sorry, it's my fault. just not following what the difference is between social assistance and social security. You've referred us to paragraph 46 of S. Sorry. Yes, 46 of S and 61 of Bray, which are in virtually identical terms.
Yes.
Which identifies social assistance as something that seems to me very broad. All assistance schemes to which recourse may be had by an individual who doesn't have resources sufficient to meet his or her own basic needs and those of his or her family. And then you've referred us to the new case, which, as I understand it, doesn't address social assistance as such, but identifies what's meant by social security benefit.
Is the difference social assistance may require assessment,
Yes.
whereas social security is a blanket amount you get because you are unemployed or you are on maternity leave. You get a flat rate regardless of your actual needs.
Yes.
Social assistance potentially tops up those needs once you've got your blanket social security amount. Am I right?
I very gratefully accept that distinction. So there's one factor is that the court repeatedly draws attention to is the exercise of discretion instead of prescribed legal criteria. A second factor is the element of means assessment, that you can receive carer's allowance and be a millionaire. You can't receive universal credit and be a millionaire. That's a critical distinction in the court's learning.
It may not matter, as my lady says, but just for my benefit, what I think you said a moment ago that the non-contributory, special non-contributory benefits are viewed as being a form of social assistance. It seems a bit odd to me. On the face of it, they seem to be social security, but it may not matter.
Well, what the court says is that they have features of both.
Right. Well, that I can understand.
And certainly in Darno, there's a indication that if you're picking one of the two to align them with, you pick social assistance. But it doesn't matter on the facts of our case.
Well, that's. No. I'm sorry to interrupt, but I do feel we're getting into deep waters here, which we really don't need to.
No, I think that's right.
Of course, we need to understand the background law, and we've examined that. But as I understand it, the key features in this case is that carer's allowance is social security. That means it didn't actually matter whether the husband was as rich as Croesus or poor as a church mouse.
Yes.
He got a fixed amount of care allowance to recognise the caring he was doing. The ones in the other column, the social assistance ones, are more complex because they have a relative, some means test, some assessment of needs, some contributory, some not contributory. We know some are contributory because we know carer's allowance knocked off certain sums. What more do we actually need to determine the issues we need to determine in this appeal?
The only additional point that I'd add to that summary before moving straight on to ground 2 submissions is that there is separate legislation in 883/2004 that governs the question of which member state should be responsible for paying the EU citizen social security.
And the relevance to the grounds of appeal here?
That's why we're right that social assistance in 2004-38 is to be read as meaning what it says and not to be a reference to the welfare system more generally. So
do please expand, but I think sometimes you can be in danger of getting so involved in the detail that you lose sight of the issues.
There's nothing more that I want to say about that, my lady, and I'm grateful for your recapitulating it back to me, which, as I to say I gratefully adopt. So, ground 2, I mentioned at the very start of my submissions that there were 3 key facts. This ground concerns the second of those, which is that V and J had between 2017 and 2020 the same income as UK nationals. And it's somewhat surprising to see the Secretary of State arguing that a level of resources that she provides to UK nationals are in some sense not sufficient. In this case, the household 2017 to 2020 income was £30,103.80 a year. And you'll find that you can derive that figure from looking at paragraph 16 of the Upper Tribunal judgment, which gives the monthly income, core bundle 80, and then multiplying it by 12. That level of income is very, very far from the sort of situation that Upper Tribunal Judge Ward was considering in VP that my own friend mentioned, that there is an understandable interest of the legislator in ensuring that you don't create an economic underclass of people who are motivated to live on a vanishingly small income, but assert that that's enough in order to secure residence rights later. I'm going to deal with 2 points made by my learned friend. The first, his assertion that the Upper Tribunal picked the wrong level to assess resources against. And second, his assertion that V needed to have access not just to a share in the amount of resources, but to the whole amount of the resources by himself. As an introduction to that, because obviously this requires the court to grapple with what Article 8.4 means, we say that Article 8.4 is a very straightforward provision. It establishes a ceiling for self-sufficiency, and it precludes the imposition of a floor. So if a person has resources at or above the ceiling, they must be self-sufficient. Member State can't say, but look at your particular situation. There's something unusual about it that means that we can say that you're not actually self-sufficient. But a Member State can't lawfully identify an amount that a person's fallen below and then decline to ask any further questions. If they establish that they're below the ceiling, there has to be further investigation of their personal situation. And our position on how Upper Tribunal Judge Ward applied Regulation Article 8.4 is that he correctly identified that in this case, V met the ceiling. And that's enough to conclude that he's self-sufficient. So I've said I'm going to address 2 arguments against that of the Secretary of State. First the wrong level, and then the Secretary of State characterises it as stretching. The first error that Upper Tribunal Judge Ward is accused of would be a curious error for a very experienced specialist social security judge to have made, because Secretary of State is essentially saying you didn't think about how the benefit system actually works. I've referred in my skeleton, to save time, I'm not going to invite you to turn it up now, but again, for your note, the cases of Cook and Jones both invite the mainstream courts to exercise caution when it's asserted by a party that the specialist appellate courts have gone wrong in relation to an area that relates quite closely to their expertise. Now, that's by no means a submission that the judgments of the specialist courts are immune from correction, but it's simply an indication that the social security system is very complicated and that there's a reason why Parliament has established specialist courts to adjudicate on them. The relevant parts of those cases are Cook, paras 15 to 16, which is tab 11, page 257, and then Jones, paragraph 16, tab 9, page 222. My submission is that Upper Tribunal Judge Ward did not make the mistake of confusing the point at which a person would become entitled to social assistance and the amount of social assistance they would get. That's the basic point made at para 59 of my learned friend's skeleton. It's just not right. The point at which income, so for example, from a person's private pension or from some other form of unearned income, means that you cease to be entitled to social assistance benefit. In the case here, it was ESA. In another case, it might be universal credit. It's not different and significantly higher than the amount that you'd receive if you didn't have any income. It comes off pound for pound. In the bundle is section 4 of the Welfare Reform Act 2007, which is tab 1, page 7. I invite you to turn that up and just look at section 4.1. So just to present some example figures to show how that works. If you have, you'll see there's a reference to a person's income and a reference to their applicable amount. If your applicable amount is £100 and your income is £95, then applying 4.1, in the case of an income-related allowance, the amount payable in respect of a claimant shall be A, if he has no income, the applicable amount. B, if he has an income, the amount by which the applicable amount exceeds his income. So £5 there. You have an income of £100 and an applicable amount of £100, you don't get any benefit. One of the reasons why the winter fuel allowance changes proposed by the current government have been controversial is that a person who has a state pension that is exactly equal to what their applicable amount for pension credit would be doesn't qualify for pension credit, and so will lose out on a winter fuel allowance, even though the amount of money that they have is no more than a person who doesn't have a state pension is on their pension credit. So my submission is the pretty elementary one, that the Secretary of State's argument just doesn't work. In our social assistance system, the default rule is that if you have some income, that reduces the amount of social assistance that you get. I anticipate that what the Secretary of State may say is, well, there are some circumstances in which there might be some extra support. Social assistance is a diffuse category. We've seen the Court of Justice saying that it can include local systems and a range of ways of operating, perhaps a range of rules for how income is taken into account or the levels at which a person qualifies. In my submission, that point is met by Chacroon, and I wonder if the court could turn to tab 20, page 500, paragraph 52. Chacroon was a case where the Netherlands had tried to fix a set amount for self-sufficiency, and the court did not allow it. One of the points the Netherlands made was the point that I've anticipated from my learned friend, well, that there might be some situations where the special forms of assistance available in different rules, or income support measures in the context of minimum income policies. The court takes a sensible, practical approach. The concern of the directive is with the headline rule, and that the existence of special, exceptional exceptions to that principle doesn't it doesn't permit departure from looking at the headline. So the court says at 52, the answer to the first question is that the phrase recourse to the social assistance system in Article 7.1c of the directive must be interpreted as precluding a member state from adopting rules in respect to family reunification, which result in such reunification being refused to a sponsor who has proved that he has stable and regular resources which are sufficient to maintain himself and the members of his family, but who, given the level of his resources, will nevertheless be entitled to claim special assistance in order to mean exceptional, individually determined essential living costs, tax refunds granted by local authorities on the basis of his income, or income support measures in the context of local authority minimum income policies. That's really the only way you could make Articles 7 and 8 of the directive workable, given the potential range of social assistance systems. The Secretary of State says that on the Upper Tribunal's test, self-sufficiency would lack any substantive content. I submit that on the Upper Tribunal's reasoning, that's not the case at all. Upper Tribunal Judge Ward read Article 7 as requiring the disregard of resources which represent any increase caused by the EU citizen on the demands of the host state's social assistance system. So, in a case where a person has created an extra burden, has risked, or is part of a class of persons that risk disrupting the equilibrium of the social assistance system, you can't rely on that, on Upper Tribunal Judge Ward's reasoning, to claim self-sufficiency. That maintains self-sufficiency with a considerable substantive content because it protects the state from that burden. It does everything that it legitimately could do. I want to move now to the Secretary of State's second argument, the stretching argument. The Secretary of State says that Upper Tribunal Judge Ward didn't properly consider that resources had to be stretched between all members of the household. Well, I submit that the evidence that he did is that the test he applied was not the single person rate of social assistance. It was the household rate. So Upper Tribunal Judge Ward is saying, it is applying the test in a way that it wouldn't be possible for a UK national receiving the rate that covers a single person to say, well, I'll just give all of my resources to my EU national partner. In those circumstances, Upper Tribunal Judge Ward's test would lead to a person failing that because they'd say, well, there it doesn't stretch. You've got, the resources you've got to show have to be enough for the household. The Secretary of State says it's curious, that para 66 of her skeleton, that there's a stricter test if there are multiple family members under the directive than if there's just one. Well, with respect, I submit that's not curious at all. That's entirely consistent with the scheme of the directive. The purpose of the test is to ensure that people coming here from other EU member states don't burden the host state's social assistance system in unacceptable ways. If two people come, there are more risks of burdens than if one comes. They have more needs. So that point in my submission doesn't work. I think I've taken the court already to paragraph 37 of Bajratari, but I'd just like to turn back to it in case I didn't show you the paragraph that I want to now. It's so tab 28, page 743. It's the final sentence of paragraph 37 that I'm drawing attention to here. The court's concern is with the union citizen becoming a burden on the social assistance system. So when you've got a family set up, it's the union citizen, or I entirely accept if you had two union citizens coming, it would be both of them. But here, in our case, we just had one. It's the burden that he might present that is the legitimate concern of the directive. Now, my final point on ground 2 relates to the question that my Lady Justice King asked yesterday, and I'll deal with the clarification that Mr. Cornwell gave this morning to his answer. I understood my lady's question to be, if an EU citizen coming to join a UK spouse had sufficient resources for him, but not the whole family, would he have to demonstrate a right of residence under Article 7? Would he have to have enough resources, not just for him, but also for his wife? The Secretary of State accepted that it followed from his argument that if they just had enough for him, if there were sufficient resources only for him, there'd be no residence right.
I think the caveat is notwithstanding that she was a UK national.
Yes. The clarification that Mr. Cornwell offered this morning deals with the operation of Article 8.4, the requirement to examine the personal situation of the person concerned. But my lady's question operates on the premise that even after that has been correctly applied, the conclusion is that they lack sufficient resources. I want to draw attention, my final point on ground 2, to the consequences of that argument. So imagine, in this case, that there's a relatively small amount of resources in the name of V. But imagine a different situation where an EU citizen had, for example, a private pension, and the amount of that private pension was significant and it was sufficient for an individual. So in that hypothetical scenario where they have, I'm not quite, I suppose, not quite sure what the amount would be, but more than £1,000 a month, something like that. In that scenario, the Secretary of State would accept that that person could come to the UK and live in the UK by himself. The Secretary of State would submit that that person, assuming that the correct application of Article 8.4 showed that the resources were sufficient just for themselves and their family members, that that person could not move in with his wife, because then he would lack a right of residence, lost it by changing his household situation. The reason I want to draw attention to that is because, as the court will know, a commonly prosecuted form of social security fraud is when people fail to declare that they're living with a partner. The reason for that is that your partner's resources are taken into account. You're often financially better off to live separately. If the person with a substantial private pension moved in, that money would come pound for pound off their wife's social assistance entitlement. So you would see a huge relief of the social assistance burden on the United Kingdom. And yet that's where the Secretary of State's argument gets her to. That because of the way that she invites the court to read Article 7, a situation which separates families and which costs the member state extra money, because the tendency would be, I suppose, in that scenario, for them to live separately, is nevertheless the only permissible scenario. That really would, in my submission, be a very surprising conclusion. And while it's not, I've argued this case from first principles rather than backwards from its consequences, but it's a useful cross-check as to what I say is the flaw in the Secretary of State's argument, that it leads to absurdity, ultimately. let me move now to ground 3. This is the question of the reasonableness of burdens. I'm going to divide my submissions on this ground into 3 parts.
Sorry, Mr. Royston, can I just interrupt you for
Yes.
one moment? Just from our discussions yesterday afternoon, I'd anticipated we would be finished by the whole case by about 12:30. It's not looking good at the moment. If that's the case, I've arranged meetings for 12:30, so I need to get hold of my clerk and cancel.
Oh, I'm sorry. I would.
No, not at all. We were listed for half a day. I perhaps wrongly anticipated how long you were going to be this morning.
I think I will be. Well, Mr. Cornwell had thought that he'd be half an hour in
Yes.
reply. I'm certainly not going to still be going at 12 o'clock.
Very well. I mean,
So-
I don't want to,
No, I was going to offer sort of 15 to 20 minutes as a
That's-
guess. I know that council's time estimates are notoriously
well, never help by
unreliable.
questions from the bench.
I'll
But
be
very well.
astonished if
Well-
I'm still on my feet at
Well,
12 o'clock.
We'll see how it goes.
So it depends on your.
But it
yes.
may be I might just have to make arrangements if things slip. But thank you.
Thank you. Point 1, I'm going to make the case that there is a need for an individual assessment. The Secretary of State's case on this, I'm going to submit, is slightly ambiguous because there are some points of agreement, but there's some parts of the submissions that in my submission are effectively arguing that there's almost no role for individual assessment of the reasonableness of the burden. My second point will be to argue that this assessment was at heart a question of fact, and that this ground is a scarcely concealed disagreement with findings of fact. There aren't really points of law in this ground at all. And then third, a wash-up dealing with the Secretary of State's criticisms of how the judge went about his making his findings, dealing in particular with the question of the wider impact of the decision, which it's common ground that the court needs to consider. It's very clear from Bray. So, point 1. We agree with the Secretary of State when she says in her skeleton at paragraph 38, where an EU citizen has a right to reside as a self-sufficient person under Article 7(1)(b), but circumstances change, so they need to apply for social assistance in the host state and potentially lose that right to residence, an individualised assessment is necessary of the burden that would be placed on the social assistance system by granting the individual such social assistance. And it's worth identifying that in the Upper Tribunal, the Secretary of State specifically reserved a right to argue that Bray was wrongly decided above, and she is not doing that. My learned friends just said that I didn't appear in the Upper Tribunal, that his precise point was that AMS, he said, was wrongly decided in how it interpreted Bray.
Oh,
so
right, thank you.
Bray, but indirectly.
Yep.
Let me show the court Bray 75, para 75, which is at page 578 of the bundle. Conclusory part of the court's reasoning on this question.
I'm sorry, which page?
578, my lord. Sorry, and it's tab
22.
yes. Thank you, my lady. Tab 22. 578, paragraph 75. the mere fact that a national of a member state receives social assistance is not sufficient to show that he constitutes an unreasonable burden on the social assistance system of the host member state. And that principle arises from what the Court of Justice said in Grzelczyk, paragraph 44, which is tab 16, page 395. The last 5 lines of paragraph 44 have been endlessly cited by the Court of Justice since the Court made that ruling. It's dealing with the predecessor directives to 2004-38. Nothing turns on that. It accepts a certain degree of financial solidarity between nationals of a host member state and nationals of other member states, particularly if the difficulties which a beneficiary of the right of residence encounters are temporary. Paragraph 45, it occurs to me it's possibly worth noting as well. This Grzelczyk was dealing with a student where there are self-sufficiency conditions in the same sort of way, and the court makes clear that the assertion of self-sufficiency is to be assessed only as at the time when it's made. A student's financial position may change with the passage of time for reasons beyond his control. That's perhaps relevant to a question I was asked yesterday by His Lordship, Lord Justice Popplewell. Now, taken by itself, that part of the Secretary of State skeleton at 38 would have been enough for me to say, well, we're agreed about the law. But then having given that with one hand, paragraph 77 of the Secretary of State skeleton, my submission tries to take away with the other. And the underlying argument of paragraph 77 seems to be that Garcia Nieto and Alamanovich show that in any given case, the burden will always be unreasonable. The Upper Tribunal erroneously failed to appreciate that the CJU had indicated that such an accumulation of claims was bound to impose an unreasonable burden on the host state's social assistance system. Then my learned friend goes on to say the relevant discussions by the CJU being apparently general in their scope and not tied specifically to consideration of the first 3 months of residence or retention of worker status. For that to be right in my submission, Bray would have to be wrong. I say the Secretary of State isn't right about the scope of those cases. I say that Garcia Nieto is indeed tied specifically to consideration of the Article 6 initial 3-month period. The Secretary of State cites paragraphs 45 to 50 of Garcia Nieto in the skeleton. He stopped one paragraph too early, I say, and if the court could turn to page 717, tab 27, page 717. So the Secretary of State has just said it is apparently not tied specifically to consideration of the first 3 months of residence. So that's the Article 6 circumstances. Paragraph 51 reads, Article 24.2 of Directive 2004/38 does not preclude national legislation such as that of the issue in the main proceedings, insofar as it excludes nationals of other member states who are in a situation such as that referred to in Article 6.1 of that directive. So my submission, it is tied specifically to consideration of that period. In my submission, exactly the same point can be made of Alamanovich. And I'd invite you to turn that up now, page 674, tab 25. Page 674, tab 25, paragraph 63.
Sorry, paragraph.
63, my lady.
Thank you.
Where the court, using very similar language, says Article 24 of Directive 2004/38 and Article 4 of Regulation 883/2004 must be interpreted as not precluding legislation of the member state under which nationals of other member states who are in a situation such as that referred to in Article 14.4b of that directive. People who have temporary entry seeking work but haven't found it. It comes from a case that may be familiar, called Antonison, from 30 or 40 years ago in the court's case law. So people who have never worked, they're temporarily in a other country looking for work and haven't found that work yet. If those paragraphs weren't clear enough, the court may also wish to note that both of those cases specifically cite and agree with Bray. So they don't in any way suggest that there's a defect in the Bray analysis. They're just specifying places where it's not required. So paragraph 46 of Garcia Nieto, and then 59 of Alamanovich. 46 of Garcia Nieto, 59 of Alamanovich are both specifically citing and agreeing with Bray. So in my submission, that establishes point one of my submissions on ground 3. There is actually a need for individual assessment. So the Secretary of State can't cut the legs off this argument right at the start. Part 2 of this ground is to submit that Upper Tribunal Judge Ward was right when he refused permission to appeal. This was at paragraph 9 of his permission refusal, page 102 of the core bundle. First paragraph of his very detailed analysis of the Secretary of State's case, which hasn't changed substantially since it was advanced to Upper Tribunal Judge Ward, identifies in my submission correctly that this is a case of disagreement with application of uncontroversial principles to the facts of the case. As he says, that's not an error of law. Now, in the Upper Tribunal's judgment, which you'll see, my lady and my lords, pages 93 to 95 of the core bundle, paragraphs 57 to 61. The judge set out the test in some detail. And he took important parts of that from his own case, which is currently the lead authority on that, AMS, the second interim decision in AMS. It's particularly paragraphs 46 to 55 of AMS that are cited. I don't invite you to turn that up, but you'll find it at tab 13, starting at page 311 of the authorities bundle. So 46 to 55 of the second interim decision in AMS. It's, the court will probably have noticed that you've got two AMS decisions in the bundle, so it's the first of the two. The Secretary of State isn't challenging the test here. She's just saying that Upper Tribunal Judge Ward misapplied it. I've already invited the court to have regard in considering ground 2 to the principles explained in Cook and Jones on the approach of a court such as this one or the Supreme Court to decisions of the specialist social security appellate courts. This court will no doubt also have regard to Upper Tribunal Judge Ward being a particularly experienced judge in this area. He's been responsible for deciding a lot of the cases on self-sufficiency. My learned friend's going to take you to an extra one later today. He also decided VP and decided AMS. The arguments of the Secretary of State, as I'm going to attempt to show in the third part of my submissions on this ground, come nowhere near demonstrating an error of law. There's really just disagreement with facts. As the Upper Tribunal said in refusing permission to appeal, and this will be particularly relevant when we look at how the Secretary of State's criticism of the Upper Tribunal's analysis of the overall burden of the class of people who would be affected. The Upper Tribunal did the best it could with the evidence provided by the Secretary of State. And you'll see that further down, paragraph 9 of the decision refusing permission to appeal, page 102, where he says at grounds 24, it's the penultimate paragraph on page 102, it was open to both parties to submit such evidence as they saw fit. The Upper Tribunal was provided with little to go on, but as a specialist tribunal and with a judge who's one of a small subset of judges handling cases involving the right to reside, was entitled to reach the conclusion it did on what it had. My Lord Justice Popplewell asked yesterday a question about whether, on whom the burden of proof lay to show that a burden is unreasonable. I invite the court to look quickly, before I move on to the third part of these submissions, at two cases which show that the burden is, as one would expect, just on the general principle that the person asserting must prove, in line with the EU law principles I outlined yesterday, that limitations on fundamental rights must be shown to be proportionate, which implies the burden is on the host state. There are two passages of Advocate General's saying precisely that. The first that I invite you to look at is in GV, tab 33, page 934. And it's paragraph 126 of the Advocate General's opinion. Talking about limitations of residence rights. I invite the court to pick it up from "it is clear to me" and read all the way over the page to the end of the paragraph. You'll see from the footnote 67 that there's a reference to the judgment of the court in Bressol. I wondered about whether to bring you Bressol, but haven't, because Bressol is dealing with the state's duty to substantiate a limitation in a slightly different context of where the public policy is at issue. So I thought that it's slightly too distant to be worth adding further to your already very large bundle of authorities. But it's clear that the Advocate General in GV thought that there was no reason of principle to distinguish. The other very, very similar passage is at 890 in S, and it's paragraph 92 of the Advocate General's opinion. About the need to substantiate risks. It's the whole of that paragraph that's relevant to your note. Okay. So in the third limb of my arguments, I say that none of the Secretary of State's criticisms do demonstrate an error of law. They show disagreement with factual findings. Secretary of State has 5 points. I responded to all of them in the skeleton, and I rely on that. I'm just going to pick out 2 of them to address orally. The first is paragraph dealing with the point made at paragraph 72 of the Secretary of State skeleton about the relevance of the future period. And then the second is the points made at 74 to 77 of the Secretary of State skeleton about the size of the affected class. So regarding the relevance of how long dependence on an extra amount of social assistance would continue, the critical point that I invite the court to bear in mind is that the causative potency on the facts of this case of giving extra social assistance could not go beyond May 2022. The reason for that is because then B would be entitled anyway, by virtue of a decision that was already in train. Secretary of State doesn't suggest that there's anything wrong with what Upper Tribunal Judge Ward says about that he had pre-settled status, he had a clear expectation that he would get settled status, which indeed he did, and it was already known when he would get that, and it didn't depend on any relevant factor here. He didn't need to demonstrate a period of self-sufficiency in order to get settled status, in order to get indefinite leave to remain as a matter of domestic immigration law. Simply as a point of logic, it's obvious why a limitation on rights would be interested in the causative significance of a factor, because if you're trying to protect your social assistance system from threats that might burdens that might unbalance it, you're not going to be concerned about things that would happen anyway. I'm not going to take you back again to Bray, but in paragraph 61, which you've looked at several times of Bray, the court uses the words "by reason of that fact." So it's interested in the causative link between the exercise of free movement rights and the consequences for a member state's social assistance system. The further reasons why we say that the Upper Tribunal was right to look simply at the period from July 2020 to May 2022 is that the condition in Article 7.1b is to have sufficient resources not to become a burden on the social assistance system of the host member state during their period of residence. Now, one might ask, well, what does that mean? Does that just mean literally all the time that they're living in the member state? In my submission, during their period of residence means during their period of residence on that basis. And recital 10 is yet again very helpful in helping us construe that. If the court looks back at recital 10, page 171, persons exercising their right of residence should not, however, become an unreasonable burden on the social assistance system of the host member state during an initial period of residence. In my submission, that makes clear that the concern of Article 7.1b is with the burden there and not the potential later implications. That's a point I take from a sort of black letter statutory construction analysis. There are strong policy reasons as well. It would be potentially impossibly speculative to require assessment of a person's lifelong position. And it would unbalance the system established by 2004-38 of providing a certain period when a state can have legitimate questions to ask about the effects of EU nationals' presence in its territory, and then later on it can't because it has to grant permanent residence. But the core point here is that on the facts of this case, there's just no causative link. In a different case, there might be an interesting argument to be had about whether a person, I suppose now we've left the European Union, this would have to arise in a different member state. There might be an interesting question of European law to be determined where a person was resident asserting self-sufficiency and then at the end of it wanted to assert a right of permanent residence under Directive 2004/38, which requires prior residence for 5 years in accordance with the directive. Could a court look beyond the 5-year period in assessing the burden there? Well, I've made some submissions that suggest that perhaps it couldn't, but that doesn't arise here. On the facts of this case, it was known at the point of the request for extra social assistance that it would be for a closed period, and that the provision or non-provision of it would make no difference to the burdens on the state beyond that time. Then my second point is about what the Secretary of State says about the size of the affected class. These are submissions made at 74 to 77 of the skeleton. A significant part of the Upper Tribunal's reasoning is that V had spent 3 years in the UK, 2017 to 2020, during which time his presence hadn't caused any extra pressure on the UK social assistance system. In fact, it made it reduce. The Secretary of State defines the class much more widely than that. And I'm going to take you quickly to what's called an Advice for Decision Makers memo, which is decision-making guidance issued by the Secretary of State to her officials about the implications of the Upper Tribunal's decision in this case. That starts at page 63 of the supplementary bundle. Which is tab 9. And the relevant part is paragraph 7 of that advice, which shows how the Secretary of State is attempting to define the impact of the class affected by the decision.
Sorry, where are you taking us to?
Sorry, paragraph 7, which runs over pages 64 and 65. And then you'll see that that there's a heading paragraph, and its final sentence reads, "The effect of the Upper Tribunal decision appears to be that an EEA national may be considered as having been self-sufficient for the purpose of claiming UC when they satisfy all the below conditions. 1, have PSS. 2, do not have any other right to reside. 3, rely on their UK partner's legacy benefits, for which the benefit award was calculated at the couple rate to be considered as self-sufficient. And 4, then make a joint claim to UC with their UK partner." That definition is wrong, and the key part of the wrongness of it is point 3, because point 3 would include people who increase the burden on social assistance. In fact, the vast majority of that group would be people who increase the burden. The way that universal credit is constructed and taken you to the authority that member states are free to organise their social assistance systems as they want. The way universal credit is constructed has made this sort of situation even rarer, because it would make it less likely that a person entering the household did decrease the burden on social assistance. So they have not correctly defined the class, and then at the prior tab, tab 8, page, I'm sorry, my note is, I've written page 30, but I don't think that's
56. I think it's page 56
yes,
if we're looking at tab 8.
Thank you, my lady. It is. I don't know why I've written page 30. That evinces a freedom of information request about the number of cases affected by this appeal. There's a freedom of information request made by Mr. Williams, who's sitting behind me and who argued the appeal in the Upper Tribunal. Over the page at 57, the Secretary of State has paused the mandatory reconsideration. So that's the stage when somebody says, oh, I think your decision's wrong. Can you look at it again? So prior to appealing. There's 21 cases. And that's on the excessively broad definition of the impact of this case that I've attempted to demonstrate that the ADM guidance shows. There are 6.5 million universal credit claims. This appeal concerns an unusual set of facts, and because it's an unusual set of facts, it doesn't affect very many people. Upper Tribunal Judge Ward was entirely right to conclude that the impact of accepting the limited degree of financial solidarity between a member state and a person settled here for some years who's caring, who's living with his wife here, is not unreasonable. As I've said, grounds 2 and 3 of this appeal, in my submission, don't raise any error of law. And
Can I ask you about one specific submission?
Yes.
Mr. Cornwell has made in writing at page 27 of the core bundle.
yes,
At paragraph 75. A specific argument he makes is that the judge was wrong in defining the size of the cohort, because although V might have had only 23 months until he obtained settled status, others in the cohort could have had longer, up to 5 years. Do you accept that point?
well, there are two factors. I don't accept that demonstrates any error, because there are two factors. If you're claiming it for longer, the decision maker, whether it's the Secretary of State or a tribunal, is making an individualised assessment. And you might conclude that the burden is not reasonable, particularly when you take into account that the person has been living in the UK for a shorter time. So a person, it's completely clear that from the Upper Tribunal Judge Ward saying this case probably wouldn't have got off the ground, that it's going to be very unlikely that a person can come to the UK and almost immediately make a Bray-type claim upon financial solidarity. The longer you've been here, the better your chances of saying, well, you should support me just for a little bit. There's no reason to think that Upper Tribunal Judge Ward didn't recognise that there could be cases that cost more, though not very many, but he wasn't dismissing that as a relevant factor. He was well aware of it. Does that address my Lord's question? I wonder if I might turn my back. I've not kept to my promise. It's 1 minute past 12, but unless I can assist the court any further, those are my submissions.
Thank you very much. That's most
Thank
helpful.
you, Madam.
Yes, Mr. Cornwell.
I'm going to go back to ground one. The first point I want to deal with on ground one is what one might call the general legislative context, which Mr. Royston emphasised the point that we're talking about a general fundamental right to freedom of movement, and that Article 7.1b was a condition on it which needed to be read restrictively. We don't dispute that. That is quite clear, but I would draw the court's attention to the numerous passages in the judgments that we've looked at from the Court of Justice which recognise that, but also recognise that there is a balance struck by the directive, and that the conditions need to be read in a meaningful way so that they actually protect the interests identified in the directive, in this case the protection of the social assistance system and public funds. So, to the extent that that's not in dispute, but it can only be read, points that Mr. Royston raises can only be read so far. That's my first point. The second point on ground one it relates to burden. In my submission, the underlying premise of Mr. Royston's submissions, that increase in burden is critical, is not justified, and that's for two reasons. One is it fundamentally conflicts with at least one limb of Judge Ward's analysis, where he plainly considered himself bound by the cases running on from Chen, that one couldn't look at the origin of resources. And the question of whether burden increases or decreases, burden on the social assistance system increases or decreases, only comes into the picture if and to the extent that one can look at the origin of the resources that V claims to be able to rely upon, namely the resources from his wife's benefits, and in particular her social assistance payments. Whether that burden, any burden, went up or down or stayed the same, necessarily involves looking behind, as it were, the curtain that on the reading that the judge adopted of the Chen cases, it should be precluded. I wasn't quite sure at the end of Mr. Royston's submissions on ground one whether he actively supported the judge's reasoning in relation to the Chen cases or abandoned that, but tied his colours entirely to the mask of the narrow reading that Lord Justice Singh identified in paragraph 50, coming to the surface at paragraph 56 of Judge Ward's judgment. But in my submission, that there is a critical confusion on this point in the judgment. So that's the first point on burden. The second point is, in my submission, burden is something that is intended to be read in a non-pejorative sense and is something that applies to both EU national migrants and to nationals of the host member state. I was struggling yesterday to find a reference where that point was made good. It is in case of GV, tab 32. I thought it was the court. Actually, it was the Advocate General. This is at page 935 of the authorities bundle. Paragraph 131 of the Advocate General's opinion. Where the Advocate General quite clearly envisages that, you see from the final sentence, in other words, such family members are an unreasonable burden in the same way as nationals of that state are an unreasonable burden. The point is, and that is independent of whether or not the reasonableness or unreasonableness of the burden has any legal effect in relation to the right to reside of the person in question. Obviously, in relation to a national of the host state, it will have no such effect. But in relation to an EU citizen who is claiming no other right to reside and is economically inactive, it will have such an effect. And in my submission, the effect of that is that once, as I think Mr. Royston accepted one really had to, once one goes behind the supposed curtain drawn by the Chen cases and can look at origin, J was, in neutral terms, a burden on the social assistance system. And given that V was entirely relying on her resources and in large part resources of hers derived from social assistance, it must be said that he was also a burden, and that is independent of whether or not his joining the household increased or decreased or had no effect at all on the amount of that burden. He was still indirectly a burden on the social assistance system, and he became that burden when he joined the household and when they became a couple for benefit purposes.
Is that the relevant
Yes.
scenario? What Mr. Royston submits is that it's got to be a causal link with the exercise of free movement rights. And he says, he may be wrong, but he says that if V had come to live in the UK by himself and had the resources to look after himself, and I know that's not the facts of this case, but we can test the point of principle in this way. He says that the UK would not be able to say to him, you can't live here, so why should it change if he then moves in with his wife?
Because, if he comes and lives here by himself and has resources, then the assessment is on the basis of the resources he has, yes, and by reference to the needs and so on that he has, and that in the first instance is set by reference to the social assistance eligibility threshold, which in this case will be for a single person. Now, but when let's think of two scenarios. One is a scenario where he then joins the household, and the law is as it currently is, and suppose that J had in fact been in receipt of universal credit, which she might have been if she applied later and wasn't under legacy regime. In that case, he would not have been eligible because there's a right to reside test. He wouldn't have satisfied it, and there would be no question there that he had accrued any right to reside on a self-sufficiency basis. Then we have the situation that we actually have, and in that scenario, J would carry on receiving benefits if she chose to give some of them to V, just so that he could live. That wouldn't, in my submission, it might be said that he was he wouldn't be. The question of sufficiency would be obvious because the benefits have been calculated on the basis of what was needed for J on her own, and it couldn't sensibly be said that the kind of analysis that Judge Ward engaged in here applied. It couldn't be said to be sufficient. But the situation here is that he joined the household and that they became a couple, and so his presence in the household became a determining factor in the amount of benefit that was payable to J. And so, in my submission, at that point he very much becomes a burden that he is placing on the welfare system, because it changes from a situation where he actually has no impact at all to one where his involvement in the household, his presence in the household, in part becomes determinative. And the fact that we happen to live in a system where the money goes to the primary claimant rather than to both members of the couple equally shouldn't change that. So in my submission, there's nothing odd or unusual about the submission that I'm making. I'll come on to the point about some of the points that Mr. Royston makes in relation to sufficiency when I get onto the second round. The other two other points I want to make on, three other short points I want to make on ground one. The emphasis on the word become a burden. In my submission, that word does not bear the weight that's been placed on it. It has to be read in the context where the EU legislator is assuming that someone has resources and is simply, and the question is the amount of resources and whether, and viewed in the context of a potential future risk of burden being placed. And in this case, as I've said, as soon as he became a member of the family, of the household, he indirectly, through the burden that J placed on the social assistance system, himself became a burden on the social assistance system. So at that point, he, in any sensible understanding of the words, he became such a burden. Now, the exercise of free movement rights was a necessary precursor for that, obviously, causally. If he hadn't come to the UK, then none of that would have happened. But in my submission, the critical point is the point at which he joins the household, thereby gaining access to the putative resources, but also, necessarily in this context, also becoming a burden. Next short point, I've addressed S in my skeleton argument and its significance, I do make the point that in the cases that actually, Court of Justice cases that actually deal with Article 7.1b, and S was not one of them, the court is much looser in its language and uses, presumably consciously, phraseology such as the public finances, the welfare system, and so on. And in my submission, that has some weight. Which may also be connected to the fact that buried in the middle of the definition of social assistance the Court of Justice has adopted, particularly stemming from paragraph 61 of Bray, it is the concept of is public finances. Next short point on ground one. My learned friend suggests that there's no risk of V becoming a burden on the social assistance system. Now, leaving aside the point I make that he was from the outset a burden, but in my submission that is also unwarranted. If he had, for example, stopped being a carer, perhaps he'd injured himself or something, he would stop being entitled to carer's allowance, and then the balance would have shifted, and social assistance would have gone up again. If he was always susceptible to any changes in the regime, so if, for example, there had been an uprating to one element or change to one element of the whole package, that would have changed the position. So it was always inherent in his position that the circumstances that were an unusual and perilous and potentially short-lived scenario. And it was said by Mr. Royston that if one envisaged the situation where there was a registration system, that if Mr. Versnick had turned up, he would simply need to say, well, I'm going to live on my wife's resources. Well, that really is not the right answer. The decision maker would have been entitled to say, well, that's very interesting, but well, what are your wife's resources? I need to consider whether they're going to be sufficient. At which point he would have said, well, they're her social security benefits of various kinds. In my submission, it's untenable to suggest that he would have at that point been able to say, yes, and by the way, because of the obscure workings of the interaction of these various benefits, I will actually reduce the amount of social assistance my wife pays. I say that because actually when this point was raised for the first time, when the self-sufficiency point was raised for the first time, and one sees that in the submissions put in by CPAG, which start at page 89 of the supplemental bundle. And they deal with self-sufficiency at page 90. They were advanced on the basis that it was accepted that there would be an increased payment at paragraph 6. It therefore accepted that paying higher amounts of benefit in such cases did not pose, and the argument is put forward on the basis, on an alternative basis, of saying, well, yes, there's an increase, but the Secretary of State, the UK government, effectively accepted that was a reasonable burden by not imposing a right to reside test on the other member of a couple under the various legacy benefits. It only became the point that the case only focused on the more narrow point that actually there was no increase at skeleton argument stage, where CPAG did the maths in detail and spotted that point.
So skeleton argument in the upper tribunal.
In the Upper Tribunal, which is also in tab 10 of the bundle. That, I think, I would emphasise again the point that I made in my main submissions, that reading the cases properly, they are not simply restricted to looking at benefit tourism. The classic case of benefit tourism, where obtaining more generous benefits is the motive for a person moving to the host state, is one species that is covered. Is one species of the mischief that Article 7.1b is directed at addressing. Moving on to ground 2. In my submission, when one actually reads Judge Ward's reasoning, albeit he is an experienced Upper Tribunal judge, the only obvious way to read his judgment is that he is precisely focusing on the level of benefit paid and not focusing on the level of the eligibility threshold. That, in my submission, is a clear indication that he thinks he's addressing the second option under Article 8.4, and that is not the option that the UK chose. It was not required to choose it. Now, it's true that that only identifies a ceiling, but the alternative, if the person is below the ceiling, there needs to be an individualised assessment. Judge Ward doesn't carry that out. Instead, he thinks the individualised assessment is the assessment of the circumstances being carried out by the legislature in identifying the amount of payment. So in my submission, this is plainly a point of law, and it's one on which, on the fair reading of the judgment, the judge got it wrong. I think it was at that point that my learned friend referred to cases of Cook and Jones, and I'll just briefly deal with those. Cook was a case which identified that appeals from specialist tribunals needed to be subject to effectively the special second appeals test. That is now encapsulated in statute, as my learned friend showed you when we looking at section 13 of the 2007 Act. Jones' case, the decision of the tribunal that had been overruled by the Court of Appeal, erroneously as the Supreme Court held, was very much, as the Court held, a jury question. It was about whether or not serious injury had been intended. The questions that we raise under grounds 2 and 3 are nothing of that kind. They are straightforwardly points of principle as to how the judge conducted his analysis, and this court is entirely entitled to review and, as necessary, intervene if it considers them to be mistaken. My learned friend referred in the context of ground 2 to Shakroon. Given the time, I'm not going to take you to it, but the key point to note is that's not actually a case about the Citizens' Rights Directive at all. It's about the Family Reunion Directive, and the wording of Article 7.1c of that directive is somewhat different from Article 7.1b of the CRD, of the Citizens' Rights Directive. In my submission, it is correct to say that if by receiving social assistance at the specified level, one is thereby also the beneficiary or the possessor of sufficient resources not to be a burden on the social assistance system, one which essentially seems to be the thrust of the judge's analysis. That plainly, in my submission, is to rob self-sufficiency of any content and bite, contrary to the guidance of the Court of Justice in numerous cases and the clear purpose behind that provision of the directive. And indeed, just simply to state it should make clear that the position is not a coherent one. My learned friend finished off his submissions in relation to ground 2, by reference to the potential for separation of families. Now, I make 3 points as to why that argument doesn't work. The first one is we'd accept that would be ultimately, even if the threshold, eligibility threshold is not met, there would be a need for individual assessment. Second, this is a question not about whether the family is permitted to live together, but whether one member of it has a qualifying right to reside for social assistance purposes and to acquire the protection of Article 24.1 of the CRD in respect to protection from discrimination. And finally, the third point is that that's the case he was discussing, simply not this case. Mr. Versnick simply had no other resources. Moving on to ground 3, the first point I would make, on reflection, I wouldn't fully push the points that he referred to at paragraph 77 of Skeleton argument in relation to Garcia Nieto and Alimovich, and I think I'd have to accept that the analysis there is tied to the specific provisions being dealt with. However, I do cleave to the final sentence of paragraph 77 of my Skeleton argument. And the point is that the fundamental thrust of the analysis in Garcia Nieto and Alimovich in the passages cited is still entirely apposite, that any individualised assessment has to be approached from the correct starting point, that, generally speaking, referring to the context from the cases that I've referred to at length yesterday, starting point is that if you're going to receive social assistance, you receive it from your member state of origin, not from your host member state. That's the starting point, and cases such as Gazelchak and Bray refer to a certain degree of solidarity. They do not say there was full solidarity. It's a certain degree of solidarity. And that's what has to be kept firmly in mind when carrying out the kind of exercise that Judge Ward was required to undertake. And indeed, there's an indication, further indication that is unlikely to end up benefiting a claimant can be found in the case of CG. Where the court...
Tab 29.
Yes. Where the court... Yes, paragraph 80 at the top of page 790. Where the court, on the basis of the facts identified by the referring tribunal, identified that CG does not have sufficient resources. Accordingly, such a person is likely to become an unreasonable burden on the social assistance system of the United Kingdom. Now, although CG's circumstances were particularly extreme, there's no indication there that the court was limiting to that. The obvious presumption is that it will be in a relatively rare case that someone will be able to both claim to be residing under the basis of Article 7.1b and be in receipt of social assistance. My learned friend suggested all the points raised under ground 3 are simply quibbles with the facts. In my submission, they're not. The approach to the period is clearly, of the relevant period, is clearly a point of legal principle. And indeed, it's perhaps instructive to note that that is indeed the understanding that Judge Ward has in the recent decision of VB that I handed up. One of the issues in that case was whether the claimant was self-sufficient, and at paragraph 62, the judge refers to his own decision in this case and says that...
Sorry, which paragraph?
Sorry, paragraph 62. And said that, and he concludes that paragraph by saying that he is aware of this appeal, but he says that I'm going to continue to apply the law as I decided it in WV. So the judge, by that, it's not a, you may think the judge is wrong on that, but judge clearly understood him to be himself to be having identified a point of legal principle. I put BB before you. It's a recent case. It may potentially come before this court, or so I don't want to say too much about it. But I think the key points to note is that in relation to self-sufficiency, the judge very much pursued a similar approach in relation to the period and what counted as temporary difficulties, as he did in this case. So. Lest these be dismissed merely as findings of fact, is an approach that is, if it's wrong, one that potentially may be ossifying in the Upper Tribunal, and it is the entirely appropriate role of this court to step in and say if the Upper Tribunal has misidentified the relevant principles. Similarly, in relation to paragraph 74 of my skeleton argument, the points we make there about how the cohort are identified are absolutely points about principle, how the principle of the approach to be adopted by the court. I've got 5 very short points which I will deal with. On paragraph 75 of our skeleton argument, my learned friend then went off on a detour through various documents from DWP, which in my submission are entirely irrelevant. The point that was raised at paragraph 75 of the skeleton argument is based on the judge's own way of identifying the cohort. He identified the cohort at paragraph 71 of the judgment. He didn't define it closely to those who had been resident here for X number of months. He did so in broader terms, and the points that we raised there are entirely legitimate points about the principle how one approaches the kind of analysis that the judge was engaged in. The points in relation to the DWP documents are in my submission taking nowhere. Turning very briefly to the advice to decision makers.
Well, if it takes us nowhere, why do we need to look at it?
Well, I would just simply say the guidance makes clear at paragraph 7 that we're awaiting the judgment of this court, and there are various points in the analysis of the judge which are not clear. The one that he alights on says that DWP get wrong is in relation to whether or not the level of burden has to increase or decrease. Indeed, on the wider reading of the judge's reasoning, that is entirely a point that is potentially open.
I really don't think we need to examine this document.
Right.
If your point in reply is that it's not relevant.
It's not relevant. It's not relevant. What matters is what's said in the judge's judgment and our submissions in relation to it, not how guidance may have been issued. Finally, in relation to my learned friend referred to GV, I won't take you to it, but again, that's not that's another post-implementation period decision. I will stop there because I've already gone over time, my lady.
Well, if there's anything critical that you need to say, you must say it, of course.
Yes. Can I just briefly turn? So, just to conclude, we say that ground 1 is clearly a point of principle and one on which the judge erred. Grounds 2 and 3, we say the points we raise are, again, they're not quite such broad-ranging points of principle, but they are nonetheless points of principle, points of law, and for the reasons we've set out in skeleton law submissions, we say the judge erred on all or any of those points. My lady, unless there's anything else I can assist with, those are my submissions.
Thank you very much indeed. Well, thank you both very much, and also all those behind you, including Ms Thompson, for all the work you put into in the preparation of this important and difficult case. It won't come as any surprise to you whatsoever that we will be reserving our judgments. We will send out drafts, I'm not sure exactly when, in the usual way. May I remind everyone to ensure that the terms of the embargo at the top of the draft are complied with, particularly in a case like this, which is obviously of considerable concern to particularly the Secretary of State, but also the Child Poverty Action Group. Anything else I would hope we can deal with in writing, and if you can agree to an order at the end of the day, that'd be great. That would be excellent. And thank you all very much indeed.